of the two issues before the court, I will demonstrate how the Constitution does not protect interstate travel. Next, Ms. Thornton will demonstrate the constitutionality of the Chicago ordinance at issue. Your Honors, recently Chicago has been experiencing a slow housing market, shrinking property values, and poor community development. In response to this economic situation, the City Council met in February of 2006 to discuss possible causes and solutions to this problem. After analyzing a survey—
Counsel, how is this right not fundamental? I mean, people have been traveling, it's embedded in our history, and you're really going to tell somebody she's not allowed to travel from one place to another in a state?
Your Honor, the short answer is it's not fundamental because it's not supported by this nation's history and traditions. But petitioner confuses the analysis of a substantive due process judicial decision. The first step is not to first delve into the nation's history and traditions, but as taught by this court in Washington versus Glucksberg, is to first carefully define the asserted right at issue. The court in Glucksberg defined that this specificity is necessary in order to rein in the subjective components in a substantive due process analysis. The court in Glucksberg was faced to determine the constitutionality of a law that prohibited physician-assisted suicide. The petitioner in that case claimed the broad right to die. But instead of accepting this right, the court looked deeper and decided that the more specific right was the right to commit suicide, which in turn included the right to assistance in doing so. So in applying this court's instructions to the case at hand, we look to what petitioner is actually arguing. Petitioner is arguing that she has a right to travel from Oak Park to Chicago. The IRS has a term for this, and it's called commuting. And as the Fifth Circuit is held in Wright versus City of Jackson, there's no fundamental right to commute. In order to be a fundamental right, this right to commute would have to be deeply rooted in our nation's history and implicit in our nation's concept.
Well, haven't we been talking about this right since the Articles of Confederation came around?
No, Your Honor. In fact, that language mentioned by petitioner is not in the Constitution today, not because it's a fundamental right, but quite the opposite. There's no language indicating a right to commute, alongside the rights already determined by this court, such as the right to marry.
But hasn't this court held that there is a right to marry and there's a right to privacy, and those terms are not found anywhere in the Articles of Confederation or in the Constitution, are they?
No, Your Honor, they're not.
So then isn't it completely